Primary right of tenants. Section 31 to Section 37 are dealing with primary rights of tenants. So, Section 31 is about the rights to residential house. Subject to any rules that may be made by the state government in this behalf, a tenant shall have the right, free of charge, to possess in the abadi of the village in which he holds land a site for a residential house. Provisions for this proviso for this section are: first is that if he holds land in more than one village, then he may choose the village in which he wish to enjoy his concession, and he shall not be entitled to this concession in more than one village. So only one village is allowed, and that one village is according to his preference, and which he will get the concession. Rest of them will not get the concession. Next proviso for this is that further that he shall have to make an application to the tehsildar. So he will have to make the application whom to the tehsildar if he has no residential house for allotment of a suitable site for the purpose. Subsection 2 of section 31 states that, subject as overset and notwithstanding anything to be contrary contained in section 95, 96, 97, 98, and 102 of Rajasthan Land Revenue Act 1956, agricultural worker or an artisan who may have been permanently residing in the abadi of a village for like about 10 years or more shall also have the right, free of charge, to possess in the abadi of that village a site for a residential house, and the provisions contained in the second proviso to subsection 1 shall apply. Now over here it is explained who is the agricultural worker and who is the artisan. Section 32. So right to written lease and counterparts. First subsection is that every tenant shall be entitled to receive from his landholder a written lease. So this tenant will have a written lease which will be given by the landholder, and it should be consistent with the provisions of this act in the prescribed form and should contain the prescribed particulars. Subsection 2 of section 32 states that upon delivering or tendering to a tenant such a lease as is mentioned in subsection 1, the landholder shall be entitled to receive from the tenant a counterpart. Subsection 3 states that if a lease or counterpart is not received by the person who is entitled to receive this under this section, then he can bring a suit for obtaining such lease or counterpart as the case may be. Section 33. Attestation of leases in lieu of registration. So, notwithstanding anything that is contained in the Indian Registration Act 1908, the parties to a lease may, in lieu of registering the same, they can obtain the attestation thereto of such officer or person as the state government may appoint in this behalf. Subsection 2 states that such officer or person who is appointed may, after making such inquiry as may be prescribed, attest the instrument of lease in the prescribed manner, provided the proviso for this is that no such instrument shall be accepted for attestation unless presented within 4 months of its execution. Next proviso for this is that further that nothing contained in this subsection shall apply in respect of leases granted by or on behalf of the state government. Subsection 3. An instrument so attested shall be deemed to be registration within the meaning of Indian Registration Act 1908. Now, Section 34, Prohibition of Premium or Forced Labor. So, subject to any other provisions of this Act, no landholder shall accept a premium for the grant or lease or make a tenant liable to render any service of the landholder, whether for wages or otherwise, and such condition shall be void, notwithstanding any law or custom to the contrary, provided that nothing in this section shall bar the recovery of the price of land that is allotted to any person in accordance with the rules that are made under Section 100 or Section 101 of the Rajasthan Land Revenue Act 1956, or the recovery of any payment required to be made under rules made under Section 30F of this Act. Section 35, Prohibition of payment other than rent. So, notwithstanding any custom or contact to the contrary, no payment by whatever name called or known shall, in addition to the rent of the holding or any other charge imposed by law or approved by the state government, be levied on or recovered from a tenant. 36 section states the use of materials. So, notwithstanding anything that is contained in this act or any other law for the time being in force, tenants shall have the right to remove and utilize for any work in connection with his holding or residential house stones or other materials lying on or under the surface of his holding or obtained by digging during the course of making an improvement. Proviso for this is that the exercise of this right by tenants may be regulated by rules made by the state government in this behalf. Now, Section 36A is the acquisition of right to null bhat. The first subsection of Section 36A is that if any person has, since before the commencement of this Act or in the Abu Ajmer and areas since before the commencement of the Rajasthan revenue laws, has been Khatidar tenant of or upon such commencement acquires under Section 15 or Section 50B Khatidari rights in land with as well is attached thereto, and the right to realize nalbhat is in respect of such well is vested in some person other than the landholder, then such first mentioned person may apply to the subdivisional officer in the prescribed from and prescribed manner for the acquisition of such right within 1 year from the date of the commencement of the Rajasthan Tenancy Act 1959. Proviso is that the subdivisional officer may entertain an application that is made under this section after the expiry of the period of 1 year if he is satisfied that the applicant had sufficient cause for not making the application within the said period. Subsection 2 is that on receipt of application under subsection 1, the subdivisional officer has to issue a notice to the person in whom the right to release nalbhat so vest, informing him that if he desires to contest the application, he must submit his objections in writing within 30 days of the receipt of notice. Subsection 3 is this, that whether or not the application is contested, such person shall submit to the subdivisional officer a detailed statement in the prescribed form and in the prescribed manner of his claim for compensation on account of the acquisition of such right to nalbhat. Subsection 4 states that if the landholder contests the application, the subdivisional officer, after holding such inquiry as he thinks fit, can reject the application or grant the same subject to the provisions that is contained in subsection 5. Subsection 5, if the subdivisional officer grants an application, he shall determine the amount of compensation that is payable for such acquisition in accordance with the provisions of section 25, and the provisions of such section 27 and 30 shall apply to and govern the payment of such compensation. Subsection 6, nothing in this section shall affect the decision on and disposal of any application under section 29 made before the commencement of the Rajasthan Tenancy Act 1959, and every such decision shall be operative as if validly and lawfully given. Subsection 7. All such application pending at such commencement shall be deemed to have been presented under this section and shall be proceeded with accordingly. Now subsection now section 37 is bar to seizure, attachment and sale by process of court. The right of a tenant in a holding shall not be liable to seizure, attachment or sale by process of any civil court.